Welcome everybody to Landmark Chambers Water Management Part 1, Water Abstraction, Neutrality and Pollution webinar. This is the first of a two-part series on water management. Part 2 is next Monday, 6th of February. So if you haven't done so already, then of course please register for that, and we look forward to seeing you there too. So let us begin. As you know, my name is Robert Walton, KC. I'm chairing today. And we have the presentations from Matt Dale Harris, Christopher Jacobs and Charles Bishop. They will, I'm sure, be known very well to many of you already. But just to introduce them, Matt is a planning and environmental law specialist. He regularly advises the Environment Agency, for example, water companies, internal drainage boards, as well as developers, farmers, NGOs. And he will be talking, as you can see, on water abstraction and neutrality, current issues for farming and development following Harris. And then we have Chris Jacobs. He's on the public law and judicial review side more. He's a specialist in both of those. He has a particular interest in riparian and water law, and he has advised and acted in a number of cases concerning water courses, riparian rights, sea defences, flooding, drainage, coastal erosion, environmental issues surrounding coastal waters arising from the withdrawal from the EU. So obviously a good person to have on board today. And he will be talking to us about DEFRA's sewage overflows plans and the wild justice and WildFish challenges. And then we have Charles Bishop, who, as many of you will know, practices across all areas of planning, environment and public law. He's got a particular expertise in strategic litigation in the context of JR, judicial review, and he is junior counsel, being led by James Marici, for WildFish in its judicial review claim of the government's storm overviews discharge reduction plan. So he will be telling us about planning for drought conditions, water management plans, and the 2022 summer drought. So those are our speakers, and we're going to go to Matt Dale Harris first. And he will talk you through, as you can see, water abstraction, neutrality, current issues following Harris. I will see you at the end.
Thank you, Rob. Good morning, everybody. It's going to be a little bit of a canter, but I'm going to be talking about issues in relation to water abstraction and neutrality, particularly as they arise at the moment following the Harris case, and also in the context of the water neutrality issues that are being faced broadly, but particularly in the North Sussex water zone. So let's get going. The first point, and it's perhaps an obvious one, is to note that England, particularly, has been recognised as facing serious water stress for a number of years. And I've given you just a shot that all the red areas are identified by the EA as being water resource zones of serious stress. So it's a broad problem, not confined to narrow river valleys, particular river valleys or the southeast. The issue, as always, is that water abstraction from rivers and groundwater is an incredibly valuable resource. It's needed for public water supply, which of course deals not only with existing housing, but with new housing, but also agriculture and industry. And it's under an awful lot of pressure. Not only do we have significant stress already recorded in the system, but there is and has been aspirations for significant new development in England and Wales. And we, of course, are also facing the challenges of climate change, which I'll come back to later. Now, that has implications in a number of different legal regimes, but the one I'm really going to focus on today is the Habitats Directive and Wild Birds Directive context, because in many ways that provides the toughest set of legal challenges for activity, for the licensing of activity, and whether that's water abstraction itself or the building of new homes or other development. And so I've just provided a very quick overview of the habitats regime. Now, as I'm sure all of you will know, the EU directives require the creation of a network of sites SPAs in relation to bird habitats and SACs in relation to other habitats. They're now protected under the 2017 regulations, which remain in force post-Brexit, albeit that they are one of the bits of retained EU law whose future is perhaps cast into doubt by the emerging Revocation and Reform Bill. Now, there are a range of different kinds of sites in the UK, different kinds of habitats, but many of them, a significant number of them, are water-based. For example, Wye Valley SAC SPA, or the Arun Valley, or Norfolk Broads. And water abstraction and use can put pressure on the habitats contained within those sites. Most obviously, that kind of literal drying out, changes in water levels in the rivers, but there's also, and we'll come on to see how this makes a particular difference in the context of the Norfolk Broads, there are also issues that arise from changes in flow rates, because if water is moving between different salinities, between different chemical zones, then it will have the different flow rates will change the chemistry of the habitat in question, and that can impact on the often very sensitive species, flora and fauna, for whom these sites are protected. Now, there are two kind of key bits of the habitats regime which we need to be aware of. And firstly, there's the part of Article 6 which applies to the consideration of applications for permission for new plans or projects. That's Article 6.3, which is now primarily implemented through Regulation 63 and 64. And I've set out the key provisions. You have a sort of screening section, anything that gives rise to likely significant effects must be subject to appropriate assessment. And then on appropriate assessment, you can only grant permission as a competent authority if you've ascertained that it will not adversely affect the integrity of site, having regards to its conservation objectives and consulting. I'm not going to go through the case law on appropriate assessment, but suffice it to say, it establishes that a very high level of scientific certainty is required before adverse effects can be excluded. And you'll probably all be familiar with the People Over Wind case, which deals with the role that mitigation can play, only not in the likely significant effects question, but only in the appropriate assessment clause. The other aspect, Article 6, that we need to be aware of to look at the Harris case is the broader duty under Article 6.2. So this doesn't just apply when a planning authority or the Environment Agency is making a decision whether or not to grant or renew a license or to grant a planning permission. This applies generally to member states and to the entities that make them up. And it provides that they shall take appropriate steps to avoid, in relation to the special protected areas, the deterioration of habitats and the habitats of species, as well as significant disturbance of the species for which the areas have been designated. So it's a backdrop, it's a backstop duty, which applies generally. Now, its implementation in the 2017 regs is not as simple as that of Article 6.3. There is a duty to review consents which predate the designation of the site. So if you've got an SAC and there are a range of water abstractions that are licensed in relation to it, the Regulation 65 duty would have required the relevant bodies to review those consents. But it's that's a one-off duty. Further down the road, what you're left with is Regulations 9.1 and 9.3, and they, respectively, require firstly the Secretary of State and then the statutory nature conservation bodies to exercise their functions which are relevant to nature conservation so as to secure compliance with the directives. And then the second duty, which applies to all competent authorities, so effectively all public authorities who will come across these issues, including planning authorities and the Environment Agency in granting water licenses, water abstraction licenses, it requires those competent authorities to have regard to the requirements of the directives in the exercise of their functions. So the Harris case arose as a claim that the Environment Agency was in breach of Article 6.2, amongst other things, and 9.3. And the background is quite important. So we've got the Norfolk Broads, SAC, SPA, and they contain a range of SSIs, fens, broads, other kind of water bodies, effectively all water-driven, but with a range of different sorts of flow patterns and local hydrogeologies. The water abstraction permits in those catchments are all issued by the Environment Agency through its powers under the Water Resources Act. Some of the abstractors have time-limited licenses. All new abstractors will have time-limited licenses, but other historic licensees have no time limit. So there are various public water supply and larger agricultural abstractors who have a license that is granted indefinitely. There's no period for renew. In the early 2000s, all of those consents were reviewed in accordance with what's now Regulation 65, and steps were taken to address some issues. But in 2010, the claimants in the Harris case, the Harrises, provided information to the Environment Agency about a decline in the fen, which formed part of the SAC, that was near to their home, which led to the Environment Agency investigating and deciding to refuse to renew 2 significant licenses. That then went on appeal, and the inspector upheld it. And really the critical point is that as part of that process, technical work was done which undermined the logic and the robustness of the work which had underpinned the original review of consents in the early 2000s. So work was done effectively which showed that water abstraction could have a greater effect on fenland ecologies than had previously been understood. So the challenge then arose because the EA responded to this evidence by commissioning a program of investigation looking at the specific SSI where which contained cat-filled fen and which the inspector had expressed concerns about, later adding another couple. But broadly, the agency refused to expand that program as it was developing. And when it completed that work in 2021, the final report identified that abstractions within the screening area for the report investigation might be having an adverse effect on other SSIs. And the claimant said, well, if you've got that indication, you need to extend the program to other potentially affected parts of the SAC. 3 allegations, 3 grounds: irrationality, breach of Regulation 9.3, which is the have regard to the requirements of the directive duty, and Article 6.2, which was said to be directly effective, notwithstanding Brexit. Judgment was given by Mr. Justice Johnson back in September. He held that the Regulation 9.3 duty to have regard to the requirements of the directive is different to the duty to secure compliance under Regulation 9.1. However, given that it's a requirement to have regard to the requirements of the directive, the normal principle that a public body is entitled to decide to depart for a good reason is modified. And in the context of the Environment Agency's water abstraction duties, where effectively it is the only body with day-to-day control of those of water abstraction licensing, the agency must discharge the requirements of the directive, as no other public body is in a position to do so. He also held that Article 6.2 was of a kind recognised by a court or tribunals having direct effect prior to the end of the transitional period, so it continues to have direct effect now. He went on to find that in the particular context of the decision that the Environment Agency had taken, it was acting in breach of its duties or irrationally. Although it was entitled not to extend the specific programme which they carried out, the evidence was that the agency didn't have a systematic program in place capable of addressing, in whatever time period, all aspects of the risk of deterioration on the SAC, which they'd identified and accepted in the work done to date. So although the agency would be applying the findings to renewal decisions, and it didn't rule out further work on permanent licenses, that wasn't sufficient at the current time to meet the standard required by Article 6.2. Now, there are a number of, it's obviously quite a fact-specific case, but there are, I think, kind of significant wider implications for Harris, because it demonstrates the force of the Article 6 duty, firstly, which it confirms continues to have direct effect. And in a water abstraction context, this shows that for those who have permanent licenses, particularly, there is an ongoing risk, because if the scientific basis for grant or previous review no longer holds good, then the Environment Agency will be vulnerable to being compelled to take steps to investigate that if there's evidence of a probability or risk of harm. In the Fenland context, this was the increased understanding of the influence which distant abstraction could have on water flows and chemistry, even where changes in water levels were indistinguishable. Also worth noting that the judge appears to confirm the direct effect of Article 6.3, which of course has wider implications, particularly for the argument was put forward by the House Building Federation, that reserved matter applications and condition approval that are outside of the 2017 regulations. So that's Harris. Now turning to water neutrality issues. This, as I said, has primarily to date arisen in the context of North Sussex and the Arun Valley. But it's a broader concept which has been recognised by the EA for some time. Broadly, it's currently defined by Natural England as, for every new development, total water use in the region after the development must be equal to or less than the total water in the region before the new development. So it's a requirement for neutrality. It's a requirement for neutrality of water use to be measured at the regional, effectively at the water resource zone level. This is something I think that the agency originally envisaged only addressing through the water resource level process. But of course, the habitats tests have driven it to be applied to individual applications, as we see in Sussex. Now, Sussex North Water Supply Zone that's the hatched area there. It basically comprises part of the catchment of the River Arun, which is the relevant protected site, and particularly in its lower reaches. The chronology is perhaps salutary for those who perhaps might think that they're considering an area where some of these earlier steps are already in place. First of all, the Environment Agency identified the Gatwick sub-region as an area of water stress. In 2019, then, a specific problem was identified regarding the Pulborough abstraction site and the impact that was having on water levels in the Arun River. Natural England responded to that with advice that water neutrality was the only way for Sussex North that housing can be delivered, as the existing abstraction cannot conclude no adverse effects. Once that was issued, it effectively became, well, very, very difficult indeed to deliver new housing within the zone. And what we've seen since is effectively an evolution by Natural England of their advice as to what can be done to try and demonstrate water neutrality, combined with work done by the various local authorities affected to push forward a strategic answer to the water neutrality problem. So the water cycle study was published in August 2020. That's the kind of first building block really in the establishment of the strategic answer. September 21, Natural England issued a position statement setting out the interim approach that's subsequently been supplemented. And Natural England's advice is effectively this. So first, they require every application to demonstrate minimization of water use through a water budget, with the goal being 85 litres per person per day, which is, I think, broadly thought to be the lowest robust target for housing development nowadays. Secondly, water offsetting is required to entirely offset the water that is going to be used in the development and accounted for in the water budget. Now, what can be done to demonstrate water neutrality is not to offset water use is not entirely clear. So retrofitting council properties or commercial buildings is what Natural England initially suggested. They then added an endorsement of nature-based solutions. That's all very well, but getting hold of a scheme, a commercial building or a council property which can be retrofitted, and agreeing a unilateral undertaking or a Section 106 which will be effective to deliver that offsetting is pretty tricky. There's also an increasing risk of double counting if those water reduction measures are part of the Southern Water Management Plan. A couple of examples I picked out. One is a dairy farm offsetting option, which got consent quite recently, landed at Duckmore. A local dairy farm was willing to sign up to a Section 106 securing water harvesting on their agricultural barns. But a kind of an example of where it goes wrong was in the Woodford's decision, where the inspector refused on the basis that the developer had tried to secure offsetting by basically providing for a scheme for going in and retrofitting housing trust domestic properties. But the difficulty in the process was that there was no way of compelling the tenants of the flats to accept the improvements. And in that context, the inspector just wasn't willing to accept that the offsetting was sufficiently secure, having regard to the strictures of Habitat's case law, for him to be able to conclude no adverse effects on the Arun Valley SAC. We've now had, December 2022, a mitigation strategy published by the same consultancy commissioned to produce the water cycle study. And that sets out a series of options which the local authorities might be able to take forwards. There are a range of options, but it seems like the preferred option, as it emerges from that study, is that they recommend implementation of the 85-litre water efficiency target, not surprising perhaps. On top of that, seeking 40% reduction versus baseline standards for all other development. And then an offsetting strategy, effectively building on those kinds of measures that Natural England have already identified. And I'll just go through the 4 examples in a second on the next slide. But I think perhaps important to note that the offsetting strategy broadly looks to offset up to 2030. And from 2030, the authors of the mitigation strategy are effectively reliant, or they're anticipating, that Southern Water, through their water resource management plan, will bring forward changes which reduce the pressure on the Pulborough extraction. Now, it's a pretty complicated position, not least because of they're going to have to work out how they're going to fairly apportion funding, particularly if they need to deliver the mitigation to enable any housing to come forwards, but they have an aspiration to spread the cost of that mitigation across all development coming forwards during the strategy period. There's a suggested use of 5-year periods, but we'll remain to see how that's going to work. Broadly, those are the 4 options identified: flow restricts in homes, water efficient in schools, non-household waste, rainwater housing, rainwater collection, and golf course irrigation reduction. Notably, of course, well, a notable line I spotted in the strategy is they also suggest ongoing monitoring with the possibility of further offsetting to be secured. So it could get pretty complicated going forwards if they find that any of these measures are not as effective as initially modelled. It's a pretty intractable problem, and it really puts in the end a lot of emphasis on the question of when or whether Southern Water will find a long-term solution that avoids increases in groundwater abstraction at Pulborough. Given the scale of investment that's likely to be required through their next water management resource plan, it's perhaps questionable when this particular horse will ride to the rescue. Finally, I appreciate that's a bit of a canter through, but I thought it was just worth setting out some thoughts about what the future holds, because it seems to me that in some ways, water neutrality by its nature and by the scale of water, because of the scale of water that housing at the moment necessarily uses, is in some ways an even more intractable problem than nutrient neutrality. And the options for mitigation are in many ways harder and more difficult to sustain, and particularly if we run out of the council buildings, commercial properties where rainwater can be harvested. Combined with that, of course, we have increasing drought conditions. Charles is going to be talking about this drought in summer 2022, which saw, through the issue of drought permits and drought orders, increased abstraction across many water resource zones. Without serious additional investment in reservoir capacity, it seems to me that water abstraction neutrality problems are only likely to increase. And just as a taster for the climate change issues, I mean, the government's projections for the Arun and Western Streams areas for the 2050s are for rainfall to decrease by 44% in the summer, but increase by 44% in the winter, with resultant low flows being much lower and peak flows being much higher. Now, given the sensitivity of many of the species that we are talking about when we're looking at these SACs and SPAs, it's very difficult to see how those kinds of changes are not going to significantly add to the harm which even current abstraction is causing to existing species and habitats. Most water abstraction licenses now have hands-off flow conditions, which require abstraction to cease when water levels drop below a certain level. But we're going to see that those conditions coming into force, being effective more and more frequently as time goes on. So not the most cheerful talk, but certainly I think an important and interesting area for us all. Now I'll hand over here to Chris Jacobs, dealing with another hot topic area in water law, action on sewage and the wild justice and WildFish challenges.
Thank you. Hope you can all see and hear me. So I'm going to be talking about the Overflows plan and the wild justice and WildFish challenges, and there are a couple of other challenges which I will also be mentioning. So, like Matt, I'm going to be taking this as something of a canter that you have as well, and I'll summarise the key points. So essentially, what are storm overflows? They're statutorily defined under Section 141(e)(1) of the Water Industry Act 1990, but essentially they're safety valves were built into the combined sewer system by the Victorians and also incorporated into wastewater treatment plants designed to protect sewage after heavy rainfall events, backing up into streets and homes and causing floods. Their use is regulated by permits, which are issued by the Environment Agency, and in recent years, they having been intended to be used only very occasionally as a last resort, they're being used quite frequently. And the causes for this include urban creep, lack of permeable surfaces, more roads, more metal surfaces, heavier storms, and climate change, and also growing population. The extent of the overflow discharges, there are about 15,000 storm overflows in England. And in 2020, this shows the extent of the problem. There were over 400,000 sewage discharges, totaling over 3 million hours when sewage was discharging. And the figures for 2021, 370,000, slightly less, 2.7 million hours of discharges, but still substantial. And in the government's view, and probably in everybody's view, it's an unacceptable amount. In the introduction to the plan, which we'll come to, DEFRA says that in 2021, 90% of storm overflows discharged at least once, and 5% of them discharged 100 times. 8% of storm overflows discharged near a designated bathing area, which is a cause for some concern. It is addressed in the plan. And the Storm Overflow Evidence Project, which was commissioned to look into the problem, reported in 2021 that approximately 402 inland water bodies failed to achieve good ecological status, which is the Water Framework Directive baseline, because of intermittent discharges through storm overflows. The effects of sewage discharge. Well, obviously, there's a harm to public health. Swimmers, kayakers, anglers, and surfers has been well publicised, and the increased problem with gastric infections and those eating oysters and shellfish, quite well documented concerns. And in relation to marine life, the excess nitrogen, phosphorus, and heavy metals can starve marine systems of oxygen, creating dead zones where fish, marine animals can't live, can't hatch, can't breed. And of course, there's the related problem of accumulation of microplastics in water courses. This is really underpinning the whole system is the notion of enforcement. And the primary statutory tool to enforce compliance in relation to water companies that aren't complying with their duties is the Water Industry Act 1991. Section 2 we see here imposes duties on the Secretary of State and Ofwat to secure the functions of the water undertaker and sewage undertaker are properly carried out. And section 94.1 at the bottom of the page here imposes a duty to ensure that there's provision for emptying of sewers by means of sewage disposal works or otherwise. The enforcement powers, and I talk about enforcement powers here because there is heavy reliance in the plan on the enforcement regime. Section 18 of the 1991 Act empowers the Secretary of State and Ofwat to make enforcement orders to secure compliance, and there is a power to obtain information. Section 27.2 gives Ofwat that power, and that's relevant for the Marine Conservation Society case, which we'll be coming on to later. And Section 27ZA enables Ofwat to serve notice on a sewage undertaker or water supply licensee for this purpose. So those are the enforcement and information collecting powers. The second limb of the regulatory framework for enforcement in relation to obligation to maintain sewers efficiently are the 1994 regulations, the Urban Wastewater Treatment Regulations 1994. Regulation 4.2 requires sewage undertakers to ensure the provision of collecting systems, effectively sewers, and paragraph 2 confirms that that they must be designed, constructed, and maintained to the best technical knowledge regarding volume and characteristics of urban waste, prevention of leaks, and limitation of pollution of receiving waters due to storm water overflows. So we can see that that the overflows are specifically mentioned in the regulatory regime. And Regulation 4.4 imposes a duty to ensure that that the system operates effectively and efficiently. And you can see disposal routes at D there underline for treated waste and sludge, minimise the adverse effects on the environment. So it's there in the regulatory framework that that the system must minimise the adverse effects on the environment, and there are enforcements in relation to that. The final provision of note in the scheme is the Water Framework Directive, and this has been retained after the withdrawal from the European Union, and it brings into effect the water environment regulations, under which member states shall protect, enhance and restore all bodies of surface water. The legislation which brought into play the need for a storm overflows discharge reduction plan is Section 81 of the Environment Act, which was brought in as, amongst other things, as a result of the public concerns in relation to sewage discharges. And Section 81(1) amended Section 141 of the Water Industry Act 1991 from the 9th of January 2022. And one can see here that this sets out the requirement for a storm overflow discharge plan. The Secretary of State must prepare for a plan for the purposes of reducing discharges from storm overflows of sewage undertakings whose areas fall mainly in England, and reducing the adverse impact of those discharges. And helpfully, the section goes on to define what is meant by reducing discharges, and that's reducing the frequency and duration of discharges and reducing the volume of discharges. And adverse impacts is defined, reducing adverse impacts on the environment and reducing adverse impacts on public health. So it squarely deals with this issue in respect of storm overflows discharges. Going on with Section 81, the plan may include proposals reducing the need for anything to be discharged by the storm overflows, treating sewage that is discharged by the storm overflows, monitoring the quality of watercourses, bodies of water in underground strata into which storm overflows discharge, and obtaining information. And the provision goes on to say that the Secretary of State must must publish the plan before the 1st of September 2022, and the Secretary of State may at any time revise the plan and lay it before Parliament once it's published. The duties, powers and requirements that the Environment Act 2021 brings into play are dealt with at Annex 3 of the Storm Overflows Discharge Reduction Plan. I've set those out in the order in which they appear in the annex. They're not the chronological order in which they appear in the statute, but the new duties are, firstly, a duty on water companies to secure a progressive reduction in adverse impacts of discharges from storm overflows. The duty on water companies and the Environment Agency to publish data on storm overflow operation on an annual basis. Section 81, to publish near real-time information on the operation of storm overflows, so one can see exactly what's happening, where it's happening, and when it is happening. And then the duty to monitor the water quality of upstream and downstream of storm overflows, Section 82. Not all of this is in force yet, but there's a commitment in the plan to implement this legislation and bring it into force. And then importantly, the fifth new duty is the duty on water companies to produce comprehensive drainage and sewage wastewater management plans, setting out how they will manage their drainage and sewer systems over a minimum of 25-year planning horizon, and how storm overflows will be addressed through these plans. That's Section 79. Then there's a power of the government to direct water companies in relation to these actions, and a requirement from the government to produce a report setting out the actions that will be needed to eliminate discharges, and then of course the statutory plan to reduce discharges from storm overflows. So we have a package of measures in the Environment Act 2021, which are designed to provide new duties, new powers, and new requirements to address this problem. The actual plan itself was published on the 26th of August, following a consultation. It's described as the largest infrastructure project to restore the environment in water company history. And 9 water companies are set out in Annex 4 who have engaged with Ofwat and pledged, committed to reduce overflow discharges by 2025 by around 25%. And the plan sets out specific, and this is part of what's controversial about the plan, specific time-bound targets that water companies will deliver as a minimum. And by 2035, water companies will have improved all overflows, discharging into or near every designated bathing water and site, and improve 75% of overflows discharge into high priority sites. And 2050, no storm overflows will be permitted to operate outside of unusually heavy rain or cause adverse ecological harm. Now, the plan does envisage indicative spill reductions. So we can see here at 2020, reduction of 44,000, 2035, 84,000, 2040, 240,000, and 2050, 320,000 spillages, which is approximately the current level. And there's a mandatory review in 2027. There are wide expectations that water companies will ensure that their infrastructure keeps up to date. There's an emphasis on water companies preventing additional rainwater from entering the combined sewer, and there's an onus on Ofwat to improve the day-to-day environmental performance and demonstrate the actions they will take to meet targets in the plan. So there are three targets. The first target is protecting the environment. It's an ecological target. Water companies will only be permitted to discharge from a storm overflow where they can demonstrate there's no adverse ecological impact. And the headline target must be achieved for most, at least 75% of storm overflows discharging in or close to high priority sites. Now, high priority sites are at the bottom there. They're dealt with in Annex 1. You can see sites of special scientific interest, special areas of conservation. They don't appear to include coastal areas other than those which are designated, and that's part of the Marine Conservation Society challenge. The targets must be achieved for all storm overflows discharging in or close to high priority sites by 2045, but for other storm overflow sites, it's 2050. So there's a disconnect between high priority sites and other sites. The second target is protecting public health around bathing waters, and it's essentially water companies must significantly reduce harmful pathogens discharging into and near designated bathing waters by 2035. And as I said before, 8% of overflows are close to designated bathing waters, and this target applies to both inland and coastal areas, but it's not clear whether it applies to coastal areas that are not designated. There's a commitment to review the bathing water regulations by 2024, and near bathing waters is 5 km upstream of the upper limit in the inland aspects, and 1 kilometre upstream in coastal water. And then the third target is the heavy rainfall events target, and this is really a backstop. Storm overflows will not be permitted to discharge above an average of 10 on that average of 10 rainfall events per year by 2050. And a rainfall event is a maximum of 12 hours rainfall. And this, again, seemingly doesn't apply to non-designated coastal waters. The role of the Environment Agency, the government, and Ofwat. The government must complete a review by the 31st of January 2023, which we assume has happened. And there are subsequent 5-yearly reviews after that, and the targets to be looked at, reviewed in 2027. The Environment Agency is to review 5-yearly business plans put forward by water companies to assess compliance. And the plan anticipates that the Environment Agency will focus on regulatory and enforcement action. And again, Ofwat, it is anticipated that Ofwat will assess plans for efficiency, value to the consumer, and will take robust action against water companies to find and prosecute those that don't comply. Annex 5 of the plan deals with 4 proposals for the feasibility of elimination of discharges. The first is complete separation, and that is separating the combined sewer network so that wastewater is treated and rainwater redirected back into the natural environment. Now, this would involve a complete overhaul of the sewage system. It would reduce water entering sewage works, and the estimated costs are between 338 and 560 billion. So that's the first option that would eliminate these discharges. Is the construction of additional storage. Now, storage tanks are widely used in the sewage industry, and there would need to be a significant extension of this, equivalent to 40,000 Olympic swimming pools. There is an example that's already under construction, which is the Thames Tideway Tunnel, which will capture and control and store rainwater and sewage underground. There are similar projects in the United States. Achieving complete elimination using this option would, however, cost, you can see at the bottom there, 120 to 190 billion pounds. And the next option is the use of sustainable drainage systems, filtering rainwater back into the environment. And the proposal is that this is combined with storage tanks to achieve elimination. And there's a possible incentivization for soakways and gardens costing £750. So that's put forward as a potential solution. And then the fourth option are local measures, reduce groundwater infiltration, so line pipes or cracks in pipes so that water doesn't infiltrate into the sewage system, dealing with blockages in pipes, reducing misconnections so you don't connect a new system into the existing sewer system, and consumer habits, pouring fats and oils down sinks, wet wipes, etc. So those are the four solutions and options that are proposed. Now moving on to the challenges, and there are four of them. The first challenge is WildFish, and as we heard from Rob earlier on, James Marici, KC, and Charles Bishop, who speaks next, are acting for the claimant in that. And the point that is being argued in this challenge is that the plan fails to deal with the overflows that are causing the problems here and now. There's no urgency, and that the targets, the 2035, 2045, and 2050 targets, would permit regulatory breaches to continue, and that's not what the plan should be doing. So the first ground of challenge is really on exactly that point. The plan tacitly improves unlawful conduct and frustrates the existing legal framework. I've put a reference to BF Eritrea there. It's a new case dealing with a relatively new case in the Supreme Court dealing with the Gillick principle, which is that policy guidance can't direct the recipient of that guidance to act contrary to their legal duties. Over the page again, ground two, plan fails to take into account a material consideration, which of course is the urgent problem that is underway now, which the plan doesn't effectively respond to, the existing level of overflows. There's a habitats regulations ground. There's been no appropriate assessment under the habitats regulations, because these are European sites effectively. And then the plan is irrational. The plan purports to deal with all overflows, yet fails to deal with those that are current. Over to the next page, there is a second challenge, and this is brought by three claimants. Firstly, Marine Conservation, the Marine Conservation Group and others, and they're the Marine Conservation Society, a charity committed to preserving the marine environment. Richard Hallwood's Oysters, an established, I think they've been going 300 years, oyster company from Mersey Island, which is very near where I live. And Hugo Tagholm, a recreational swimmer and former CEO of Surfers Against Sewage. Now, they have four grounds. They're quite similar grounds, but there is an emphasis on the coastal waters point in this challenge. The first ground is the plan doesn't discharge the defendant's duties under section 141A, and the provision, as I said earlier, explains what it is that has to be done, and the frequency, duration, and volume of discharges. And it's said that the plan doesn't deal with that, and that the species abundance target in the Environment Act is really 2030. So it's challenging this 2035, 2045, 2050 long stop in the plan. It said that the plan is irrational because high priority sites exclude the majority of coastal areas that have been designated for their ecological sensitivity, in particular areas that are shellfish producing waters. and it has adopted a definition of no adverse ecological impact that can only be applied to freshwater sites. And there is a tension in the plan, in that the plan does, certainly in my view, focus on freshwater sites with less emphasis on coastal waters. Then there are human rights breaches, which I've dealt with there, Article 2, Article 8, and Article 1 of the first protocol. And there's a breach of the public trust doctrine, sort of an English common law challenge, the public right of piscary to fish in tidal waters, and the right to have recreational access to the foreshore. I understand that both challenges are awaiting permission. I spoke to Charles, his counsel in the WildFish case last week, and he'll update me if there's been a decision since we spoke. So moving through to the next slide, the third case is the Wild Justice case. Now, this was actually resolved on the 17th of January 2023 when Lord Justice Bean refused permission to appeal. It was a challenge against Ofwat. And what the claimant was saying was that Ofwat wasn't properly carrying out its environmental duties. It was taking a passive stance in relation to enforcement of the 1994 regulations. And permission was refused by Mr. Justice Bourne, who found on the facts that before the pre-action process had started, Ofwat had, back in November of 2021, written to a number of water companies and asked them to state the causes of non-compliance with the flow to full treatment conditions in the environmental permits, and Ofwat had taken enforcement action against 5 water companies. Mr. Justice Bourne noted that this doesn't necessarily mean that Ofwat has discharged its investigation and enforcement duties in a sufficient or satisfactory way, but the challenge failed, that Ofwat is clearly more than taking a passive role. So the claimant sought permission to appeal, and that was refused by Lord Justice Bean, who agreed with what Mr. Justice Bourne had said, and agreed with the Respondents' Council, what is an unusual case in which at a permission hearing in the Court of Appeal, Respondents was represented and spoke, and Respondents and Lord Justice Bean agreed with the Respondents' Council that it was artificial to draw a distinction between the duties in the regulation and the Act, because the Act is the primary source of the duties. There's one further case that is a matter of interest. On the 6th of March 2023, the Supreme Court will hear an appeal by Manchester Ship Company against a judgment from the Court of Appeal. Essentially, United Utilities Water was discharging into the canal, and the Canal Authority sought to bring a private law claim in nuisance and trespass in respect of the unauthorised discharges. And the Court of Appeal held that effectively there was no right because it was the statutory scheme under the Water Industry Act 1991 which governed these matters. So what the Supreme Court will be looking at, and it's a panel of 7, will be whether there can be private law claims in relation to discharges. So that will be a particularly interesting case. So finally, in relation to the conclusions to be drawn from all of this, the current challenges are primarily based on the lack of urgency, the failure of the plan to address the immediate and ongoing Section 94(1) and Regulation for breaches, and the lack of protection, certainly in the marine conservation challenge or coastal areas. The way that the plan gets around this, as I see it, is that the plan appears to adopt a presumption of enforcement. There's a section in the plan that, page 18 of it, complying with regulations. Water companies must comply with all their existing regulatory obligations and duties, including permits issued by the Environment Agency. So there's just a statement that the water companies must comply, and there's a presumption that there will be enforcement. And the claimants in the judicial review cases say that that doesn't go far enough, that doesn't meet the statutory objective. In relation to the solutions, the final bullet points there, the plan acknowledges that there are difficulties that are inherent in these options. Option 1, very expensive. It would significantly increase bills. According to there would be a bill of £122 a year from 2025 to 2029, going up to £817 a year in 2045 to 2049 if the whole sewage system was to be redesigned and reconstructed in the context of option 1. The embedded carbon options embedded carbon involved in options 2 and 3 are around 20 million tonnes of embedded CO2, and that would cause difficulties with the government's 2025 net zero target. But the conclusion of the plan is that it's feasible to apply one or a combination of options 2, 3 or 4 at a local or catchment basis to reduce charges and eliminate ecological harm. Now, I'm aware that I've gone through this at quite a canter, but you do have the slides, and I hope I didn't go too quickly. I'm now going to move on to Charles.
Oh, well, thank you, Chris, and thank you, everyone, for joining. It's really great to see so many of you here. As has been indicated, I'm going to be talking about planning for drought conditions. I'm going to start by looking at water resources management plans before then looking at specific provisions in relation to drought. And obviously, the impetus for this was last year's record temperatures, but not just the temperatures being so high, but also that this led to the driest July in England since 1935, according to the Met Office. I mean, we saw the highest temperature ever in the UK, above 40 degrees, but also because of a prolonged period of dry weather, not just in the summer, but prior to that, there was significant drought generally in the UK. And there was quite an interesting study undertaken by something called the World Weather Attribution Organization, which looked at the high temperatures across Europe generally. And the conclusion they reached was that those high temperatures were exacerbated by climate change. And it means that in the future, soil moisture droughts are going to be more likely, which is going to have an impact on water supply generally. But one of the findings they also reached in this study, which was conducted by a team of scientists, was that the droughts were exacerbated by things like poor water infrastructure and leakages, and that had a more significant effect in conjunction with climate change and other factors on why the drought took place. And there was some interesting comments made about risk planning and the importance of that going forward, about how drought risk management across Europe generally is something that needs to be developed further in order to, as they say, to move from a reactive to a proactive risk management strategy, because that's what will lead to greater organisation in relation to water resources. Obviously, the UK is no longer part of the European Union, and so that coordination cannot take place at the European Union level. But going forward, that's going to be a wider issue. So I just want to start with looking at water resources management plans. Now, these are plans that are published by water companies every 5 years under the Water Industry Act. There's specific provisions in relation to what those what the plans have to include, and generally they are plan for how the water company or water undertakers will manage and develop water resources so as to be able and continue to be able to meet their obligations to supply water, as well as their other obligations under the Water Industry Act. The plans have to set out the estimate of the quantities of water required, the measures to be taken to meet those obligations, timing of it, when are those measures going to come in, how are they going to come in, how are they going to be financed, etc. And the Secretary of State also issues directions as to what those plans are supposed to include. There is a minimum 25-year period for the plan, so the plans have to project forward for 25 years. However, guidance says that they can take a much longer view, and actually in many cases it would be appropriate to take a longer view, even up to 50 years or perhaps even further. Water resources management plans are reviewed every year, and that review can lead to a revised plan. Secretary of State can direct that the plan has to be revised, but all plans need to be revised if there's been a material change of circumstances. And all plans are revised every 5 years in any event. Now, before draft plan is prepared, there's various statutory consultees, the ones you would expect, so Environment Agency, etc. And then the draft is sent to the Secretary of State, there's a specific process that applies in relation to the redaction of commercially confidential material, and there's a specific procedure as to that. Drafts are then published for representations. They are published generally online, and those representations are then sent to the water company, and then they consider it, and then they have to publish a statement dealing with whether they've made any changes in relation to those representations. If they haven't, why not? If they have, why they have done so. And also there can be public inquiries in relation to water resources management plans. And there's the ordinary procedure for those kinds of inquiries is just the one under section 250 of the Local Government Act. And the Secretary of State may direct changes to, or the Welsh Assembly may direct changes to the water resource management plans at any point. And all WRMPs are subject to SEA and HRA assessments. The Environment Agency, Natural Resources Wales and Ofwat jointly publish a very detailed planning guideline which says all of the various things that the plans have to include, what they have to consider. The current status of plans are those that were published in 2019, and companies are currently consulting on their draft plans right now, and quite a few of them are have deadlines for representations in February and in March. So turning then towards drought, and just to flag, in a lot of the draft WRMPs, there is the spectre of further drought down the line as something that needs to be managed as part of the general water resources management plans. So water resources management plans are then complemented by what are called drought plans, which are made under the same statute. And those are a plan for how the company will continue during a period of drought to discharge its duties to supply adequate quantities of wholesome water with as little recourse as reasonably possible to drought orders or drought permits. Now, I'm going to talk about what drought orders and drought permits are in a moment. But just to clarify here that there is no definition of what a drought is under this part of the Act, but we might see where we get some idea about what droughting involves later on. And those drought plans have to set out what measures might be needed to restrain demand, what measures might be needed to obtain extra water from other sources, how the company will monitor the effects of the drought, but also any measures it takes in relation to the drought. And then again, the Secretary of State may direct that other matters need to be specified in the drought plan. And generally, it's the same procedure as is followed for drought plans. A draft gets published, you can comment on it, there's revisions to it. They're produced every 5 years. The last plans were adopted last year, and these plans are also subject to SEA and HRA. And just to flag that, the Environment Act has made some changes to the procedural requirements in relation to WRMPs and DPs. Those provisions are not yet in force. I imagine the intention is for those to come into force once the current round of draft WRMPs are being put in. The changes are not substantial. It's more about tidying up, consolidating the various provisions in relation to how the procedural requirements for the development of those plans are produced. So turning to drought in general, there is no legal definition of a drought in statute. It doesn't exist as a specific legal concept. And as we'll see, the various statutory provisions giving rise to powers following a drought use different language. Just as a matter of common law, there's no right by a consumer against water companies for diminished or suspended supply of water, because the implied contract between the two is for a reasonable supply of water, which must take account of the amount of water available to the company. And while water companies do have various duties under the Water Industry Act, including to provide a domestic supply of water, it is likely a water company could say it took all reasonable steps and exercised all due diligence to avoid the breach where water supply is interrupted in respect of drought, and there was no obvious reason why the water company should still have been able to supply water during that period. There's not been any case law on this. I suppose, fortunately, no one has needed to bring a claim against water company in these circumstances, but we'll have to see what happens as time goes on. So the first sort of big measure that is available in relation to drought are drought orders. Now, I just want to do a little bit of history here because I found this quite fascinating when I was doing some research for this presentation. The kind of legal response to drought first emerged in 1934 as an emergency act that had to be rushed through Parliament at short order following a sustained period of very high temperatures and drought. I mean, back in the 1930s, obviously, water resourcing in this country was very different. And so we didn't have the same supplies and reservoirs that we do now, and the technology available to ensure a sustained supply of water. But that act was only in place for 18 months. Government was criticised at the time for not having permanent powers in place to enable the continued supply of water during a drought. And it was principally focused about giving water companies the power to get water from other sources. What happened then is during the war, government created something called the Defence Regulations, which are a provision of emergency powers that was used during the war in relation to all sorts of matters. It was very controversial at the time, and generally considered not to be particularly compliant with the rule of law. But as time went on, those defence regulations were also used in relation to all sorts of other emergencies. So that also included in relation to drought. And there was something called Regulation 50 and Regulation 50A and 56, which were used to provide for the general legal response to droughts. And those continued as essentially orders in council made by fiat by the government, right up until 1958, when the government realized it needed to establish some permanent powers in relation to drought. And that was in the Water Act 1958. And those powers were principally about allowing for standpipes to be used in the street, and again, to find water sources from elsewhere. It wasn't until 1976 when we had, the Great Drought of 1976, when powers really had to be increased because water companies didn't have a sort of suite of options available to them to provide for different options in response to drought. And it's there that we get this concept of drought orders. And it was in relation to that, under which you had ideas of hosepipe bans, but also under how water companies were given the power to put standpipes in the street, which is what happened in the 70s. So drought orders now in the modern legislation are no longer under the Drought Act, but are under the Water Resources Act 1991. And they're generally made on an application by the Environment Agency or the Welsh equivalent, or by a water company. And they take effect as a statutory instrument made by the Secretary of State. Ultimately, a breach of a drought order is a criminal offence in certain situations. There are two types of drought order, and the main one is an ordinary drought order, which is made if the Secretary of State is satisfied that by reason of an exceptional shortage of rain, there exists or is threatened a serious deficiency of supplies of water in any area, or such a deficiency in the flow or level of water in any inland waters as to pose a serious threat to any of the flora or fauna which are dependent on those waters. And that allows for an ordinary drought order to be made. So that's where you get this definition of a drought, which is exceptional shortage of rain leading to a serious deficiency of supplies of water in any area. Emergency drought orders have an enhanced test, which is that the Secretary of State has to be further satisfied that the deficiency is such as to be likely to impair the economic or social well-being of persons in the area. And that's how the power to make an emergency drought order is triggered. Now, ordinary drought orders can allow authorization to collect, impound, divert, or appropriate water from any specified source, or discharge water to any specified place. They can allow the Environment Agency to prohibit or limit anyone, including water companies, from taking water from a specified source. They can empower water companies to prohibit or limit the use of water for any specified purpose. Although we can see the water companies already have powers, sort of more specified powers to do that, but this allows for a broader range of prohibitions on use of water. They can include suspending or modifying restrictions on abstraction licenses, and also modification of the sewage discharge environmental permits as well to make it less onerous in relation to water supply. They can also authorize execution of necessary works to fulfill provisions of the order, which include powers of entry and also permitted development rights under planning legislation. And also they provide for compensation for loss or damage sustained as a result of work done in pursuance of the drought order. Now, emergency drought orders are different in primarily two ways. The first is that they can give an authorization to water companies to enable it to prohibit or restrict use of water for all such purposes as it sees fit. So it amounts to a very significant delegation of power to a water company to completely restrict use of water in any way it wishes to do so, and in breach of which would amount to a criminal offence. What they also do is allow for the implementation of standpipes in the street, which, as I said, was the principal basis for their use in 1976. There are publication requirements in relation to those bans. Now, last summer, we did see 3 drought orders being made. 2 were on application by the Environment Agency, and 1 was on application by Yorkshire Water Services. So in respect of the Yorkshire one, the effect was to increase the maximum quantity of water it was authorised to abstract under its licenses during periods of reduced river flow. And then in respect to the Environment Agency orders, there was a concern about flora and fauna, and so that was the other basis in which the ordinary drought order power can be triggered. And the effect was to reduce the volume of compensation water that was required to be released from reservoirs under the licenses. So sitting alongside drought orders are a perhaps less onerous measure, which are drought permits. These are not issued by the Secretary of State. They allow Environment Agency or Natural Resources Body for Wales to alleviate effects of drought without having to go to government. And the agencies can issue drought permits to a water company to enable it to take water from a specified source or suspend restrictions on its licenses. In order for this to be triggered, again, the agencies have to be satisfied that by reason of an exceptional shortage of rain, a serious deficiency of supplies of water in any area exists or is threatened. Those are made on application by water companies. And I know that quite a few of those were made last year in response to the 2022 drought. Then there's one stage further removed again, which is a power that water companies have available to them as of right, and that which they don't have to apply for. And these are temporary bans. So these are made under Section 76 of the Water Industry Act, and they may be made where a water company thinks it is experiencing or may experience a serious shortage of water for distribution. So it's a lower threshold for triggering temporary bans. These are primarily used in relation to hosepipe bans. They can be made in respect of a number of specified uses of water under the legislation, and these are, I put on the slide here, the uses that can be banned under temporary ban orders. So they include watering a garden using a hose pipe, but also using a hose pipe for other purposes, things like using domestic swimming pools, fountains. I suppose you might say that all of these are perhaps non-essential items, whereas the drought orders and drought permits don't have such a restriction, and you could limit use of water under those powers in relation to ordinary day-to-day activities. That legislation is supplemented by a 2010 statutory instrument, which gives more guidance as to what exact purposes can be prohibited. The process for putting in a temporary ban is that the prohibitions have to specify the date and area to which they apply. So it has to get published on the water company's website. It has to be given, notification has to be given in at least 2 newspapers circulating in the area. That, I suspect, is a rather outdated provision. I'm not sure many people were likely to be reading their local newspaper. I think a better way of giving notice is to send letters and emails to customers and then to publish it on your website as well. And people can make representations about the ban, which a water company would have to take into account as it reviews the currency of the ban. And if a prohibition is in place, water companies do have to make arrangements for reasonable reduction of charges, which would be made in respect of prohibited uses. So that's a quick tour around all of the legal provisions available in relation to drought. So you start with the kind of strategic overview through drought plans and water resources management plans. And then there's a suite of 3 specific measures available: drought orders, drought permits, and temporary bans, which are available to water companies at various stages of urgency in response to droughts. So I think we've now finished all our presentations, and we will now be opening up for questions.
Thanks, Charles. That was super interesting. Can I just ask you straight off on the back of one question we've got, have we had any emergency orders yet?
The only emergency orders that were made, as far as I've been able to work out, were under the Drought Act 1976 in response to the summer drought in the 70s. Since then, there's never been a need to do it. It will be interesting to see if that ever changes.
Yeah, quite. All right. And we've got a load of questions coming in. We will answer. We haven't got a lot of time, but we'll answer some of them. Some of them are perhaps a bit more detailed, worthy of a legal opinion. So obviously, don't hesitate to ask for one of those. But in terms of some of the shorter ones, Matt, we've got a question in from Paul Bradford. Could water offsetting be achieved by developers by buying up and withdrawing existing abstraction licenses?
Yeah, I mean, I think Rob, the answer is in theory, yes. If you can secure the removal of a demand on the water system, that's an offset. The question is, can you do that in practice? Can you provide sufficient confidence to the decision maker? And the difficulty here would be, how do you bind that land so that you can't turn around and get an abstraction license to water it kind of the next day? That would be the tricky thing is you by comparison with the neutrality stuff, you sort of need to take land and agriculture out of operation, and just removing a license is not enough to do that. So yes, but there's more to think about, I think.
Yeah. Thank you. I hope that helps, Paul. But Stephen Kelly, another question for you, I think, Matt. This is from Stephen. Will LPAs, local planning authorities, be able to rely upon the emerging WRMPs for decision-making on planning applications, which should have been signed off by the EA or DEFRA?
Yeah, I mean, they're clearly going to be an important part of the framework for strategic approaches to ensuring water neutrality. You can see that in terms of what's emerging in Sussex, but also I know that places like Cambridgeshire are also looking at water neutrality issues with their local plans and ways to ensure that that's addressed at the strategic level by water companies as well. So yes, you can take them into account, but again, as with all habitats issues, you will have to go through the complicated and exacting business of trying to show that it is A, secured, and B, certain, which is going to be very difficult with plans for the future. Effectively, there's going to have to be quite a lot of conditionality in this.
Absolutely. Thanks very much, Stephen. I hope that helped. Chris, it's a question that's come in for you, and no doubt Charles can cover this too. It's in terms of what are the important factors going to be in the ongoing litigation? What are what's going to be important? What's going to be determinative in terms of the outcomes there?
Yes, well, it is an interesting question. It really is going to revolve around whether the plan meets the statutory objective, and whether the reliance on enforcement as a means of dealing with all of the immediate concerns is enough, or whether the Secretary of State was required under Section 82 to go further and make provision for the immediate overflows. So it really comes down to, is enforcement enough? And if enforcement is the answer, does that meet the statutory test? Yeah. There are also going to be some interesting questions in relation to what do you do about coastal waters, and why are only the designated sites dealt with in the plan? And I think that's going to be more of an argument in the marine conservation case. So I think those are going to be there is something in the plan that does talk about it's very difficult to get data in relation to coastal areas as well.
Thank you. I should declare an interest in being a member of WildFish. I'm obviously quite keen on the outcome of this one. Charles, are we going to win?
Well, I think we'll have to see, but obviously I think the claim is strong. So
great stuff. Anything you want to add to Chris's points?
No, I mean, one interesting point will also be whether plans such as the storm overflows discharge reduction plan are subject to habitats assessment. That's going to be a key point. I think there's going to be an opportunity for the court to provide some insight into scope of the various obligations at play here as well. But we'll have to see how the litigation plays out. Of course, I don't want to.
Yeah, of course. Yeah, enough.
Prejudge.
I think a question for you though is it's coming from Jacqueline Watson. This is whether there have been any significant legal challenges to the adoption of WRMPs on the grounds of inadequate SEA. So if you can unpack the acronyms for those who may not be fully familiar, that would help.
So the WRMPs are the water resources management plans that I mentioned earlier, which are made every 5 years and set out water companies' 25-year plus kind of vision for water supply in the area. And then SEA is a strategic environmental assessment. It's interesting that there's actually very little case law on WRMPs at all, and also in respect of drought. It's just not something that's got to court, which is intriguing. But no, as far as I've been able to see, there have not been any court judgments in relation to those legal challenges, which isn't to say that people haven't tried and they've not got permission, which, you know, could have brought to JR and it got knocked out at the first hurdle. So there's been no published judgment, of course.
Thanks. And Matt, one more for you, please. This is from Derek Armitage. Any legal mechanism in place that could allow LPAs to insist upon water neutrality for new development sites?
Yeah, I mean, the straightforward answer is that if you're in a zone where water neutrality is required, essentially as a matter of the advice given by Natural England, then any grant of planning permission without securing water neutrality will be unlawful and can be challenged in the courts by way of judicial review.
Thanks, Matt. Unless there was anything more from you three, I thought we could end on the wonderful image that Gillian Dawson has created for us. In the summer of '76, as part of an archaeology team on Jersey, we were limited to one bath a fortnight, and Gillian took their clothes washing in with them. So that's a lovely image. Let's hope that doesn't come around again too soon. But thanks very much, everybody, for joining. Thanks to our three presenters, and I hope that was helpful. And of course, we've got part 2 on Monday next. So please do sign up for that, and you'll see more of the Landmark team then. So thanks very much, and we wish you all well.
Thank you.
Thanks all.